Hello, good afternoon, everyone. This is David Levy, one of the partners here at Diversified. I'd like to welcome you all to our next installment of our Wealth webinar series, The Basics of Asset Protection Planning. In a moment, I'll welcome our good friend and guest speaker, Michael Salad from Cooper Levinson Law Firm. Per usual, we'll look to keep this about 30 minutes to get you back to your day, and to make this as efficient as possible, please type your questions in the questions section, and we will address them at the end if there is time. Of course, if your questions are not answered today, please reach out to us, and we'll be happy to get them answered for you. Okay, with that said, Michael, please take it away and teach us a few things today.
Thanks so much, David. Very much appreciate the kind introduction. Looking forward to speaking with everybody. My name is Michael Salad. As David pointed out, I'm an attorney with Cooper Levinson. I have an LLM, a Master's of Law in Estate Planning and Elder Law, and I'm licensed to practice in New Jersey, Pennsylvania, New York, the District of Columbia, and Florida. We're going to be discussing asset protection planning today, and I think I'm uniquely positioned to discuss this topic because I've been on both sides of the matters. Our firm is probably most well known for casino gaming work, and a lot of casino clients end up encountering casino patrons who owe the casinos money, and they often will look to me to go chase down those debtors and try to find a way to find assets and hopefully get a judgment and also recover some funds. But what I mostly do is work with individuals, many of which are on this webinar, that are looking to shield themselves from creditors. And that can come in a variety of manners, and we're going to discuss what a creditor and a debtor looks like. But the most common is some type of accident, whether it is a car accident or somebody slips and falls walking up your stoop on some ice in the winter. Those are the types of liabilities that we are most concerned with day to day. With that said, going to discuss the basics of estate planning so everyone understands what an estate plan entails and how that differs from an asset protection plan. An estate plan generally is comprised of the basics of a will, a last will and testament, a living will, which governs medical decisions, and a power of attorney. The power of attorney is the document that allows you to appoint someone to carry on your day-to-day affairs if you're unable to do so. The asset protection part of this is a little bit different because you're mostly focusing on avoiding creditor claims, and you also want to afford some level of privacy from not only creditors, but any other prying eyes. The estate planning component is primarily controlling the disposition of your assets, sometimes during your lifetime if you become incapacitated, but more so after death, and also minimizing taxes. Those taxes can come in the form of estate taxes, depending on which state you're in. There are federal estate taxes, although there's a very high exemption currently of $11.4 million per person, which is portable between spouses. And in some states, there is what's called an inheritance tax that is imposed upon the beneficiaries of your estate when you pass away. So I try to incorporate asset protection planning within the estate plan. And in this presentation, we're going to focus most of our time on asset protection. So the first item that I look to in asset protection planning is insurance. It comes in several varieties, and as David and the Diversified team know, they've been on a lot of calls with me, and they've seen that one of the very first questions I ask is about insurance. We first find out about life insurance, and the reason is it is an asset that is almost always protected from creditors. So it is an asset that will, in some cases, with permanent insurance, accumulate cash value, and in other cases, such as a term policy, will only pay out a death benefit. But you're paying premiums, and that life insurance is always exempt from creditor claims. We're going to be discussing life insurance momentarily. As David and the team also know, I always ask about umbrella insurance. We're going to be discussing what that looks like as well and how that works in probably about 3 minutes, but it's a very important component to an estate plan. Then we're going to get into annuities, qualified retirement plans, IRAs, 401ks, the use of limited liability companies. I'm going to refer to them as LLCs. And then we're going to discuss irrevocable trusts, and we're going to conclude with self-settled trusts and wrap up with some conclusions and some overall ideas. All right, on to life insurance. In virtually every state, as far as I have found in my research, there is an unlimited amount of exemption for life insurance policies absent a fraudulent conveyance. So if you know that you have a creditor claim coming, you were just sued, and then you take all of your money and you put it into a permanent life insurance policy, while David would probably greatly appreciate that, I'm not sure that it would hold up because that would be deemed a fraudulent conveyance. There's already a claim that is open, and because there is a claim that is open, now you are deemed to be fraudulently removing those funds from your name and putting them into this life insurance policy. There are some states where the cash value is capped. So let's say you have a permanent policy and you have $100,000 of cash value. Some states will say, okay, there's an exemption amount of $100,000, and then the rest of that policy, the cash value, could be reached by creditors. The one way to avoid these types of issues is what's called an irrevocable life insurance trust, also known as an ILIT. This is a type of trust that can own a life insurance policy and can be the beneficiary of a life insurance policy. And because it's irrevocable, meaning it cannot be changed or modified, it is deemed to be a separate taxpayer. And because of that, it is going to exempt you from all personal exposure if you were to be sued, because it has a separate taxpayer identification number. It can file a separate tax return, and that life insurance policy, when in doubt, would completely avoid the reach of creditors. There are also some corporate-owned policies, commonly known as group life insurance policies, which generally also applies with these exemptions. So if your employer has offered a life insurance policy, perhaps free of charge or for some nominal amount, that policy too would be included. Now, how about health insurance policies? Those also, if there's certain types of policies where you can, like a health savings account, and you can accumulate a significant amount of assets in those types of policies that are relating to health insurance, those are generally exempt from the reach of creditors as well. I have tried to keep it simple on this webinar, and I'm going to focus on either one or two states and provide examples, either my home state of New Jersey and also at times Pennsylvania, as I know a lot of the Diversified crew are, the clients are Pennsylvania residents, so I'm going to be discussing that as well. In Pennsylvania, the proceeds from a life insurance policy are completely exempt, and supplemental policies are also exempt and cannot be assigned as long as they're not assigned. In terms of the types of policies, it generally will apply across the board. On to umbrella and excess insurance. This is one of my favorites. And as David has heard me say many times, umbrella and excess insurance are very cheap forms of insurance to obtain, but extremely important. Umbrella insurance is insurance that is added to your existing, generally homeowners insurance or auto insurance policy, and it will cover all of your insurance. So let's say that David has one car and one home and one boat. He can have auto insurance policy on his car. He can have a homeowner's insurance policy on his home, and he can have a liability policy on his boat. And let's say that, for instance, the homeowner insurance policy covers $400,000 of damage. So if the house completely gets destroyed or knocked down, now he would have $400,000 of homeowners insurance coverage. But let's say that the value of the home and the contents of the home equals $600,000. Well, he could have an umbrella insurance policy, and the term umbrella means that it covers all of those assets. So an umbrella insurance carrier will require him to have certain minimum amounts of coverage for his auto policy, his homeowner's insurance policy, and his boat liability policy, but then it would pick up the delta in that liability. So in my example with the homeowner's claim, he has $400,000 of homeowner's insurance, and he has a $600,000 claim. The umbrella insurance policy would pick up the delta of that $200,000 difference. A standard $1 million umbrella insurance policy is generally in the range of maybe $300 to $400 per year. Not expensive. You get $1 million of coverage, and it is a really, really good way to protect your assets. Now, I mentioned that slip and fall on some ice this winter, somebody walking up to your house and they split their head open. And now they sue you for $1 million and you only have $400,000 of homeowner's insurance. That $600,000 delta would be picked up by your umbrella policy. Same thing for a car accident. If you have, say, $250,000 or $500,000 of coverage and you're in an accident in which you're at fault and you are sued and you have a judgment against you for $1 million, that umbrella policy would kick in. An excess insurance policy only applies to one specific type of asset. So let's say that David does not own a home and does not own a boat, but he has a car and he has $500,000 of auto insurance. He could obtain an excess insurance policy on his auto policy for, say, another $500,000 so that it would be stacked on top of his existing coverage. But generally, if you have more than one type of asset that is protected by insurance, you're going to want to purchase an umbrella policy, which can be added to either your auto, your homeowners, your boat policy, and would then cover all of that. Next, qualified retirement plans. There are a bunch of different types of qualified plans. The most common is probably a 401k plan, and there are 403b plans, 457 type plans. We're going to be discussing IRAs, annuities. These are all qualified plans. That's kind of the umbrella term. Since we've been using the word umbrella, it's kind of the umbrella term for all of these types of plans. And generally, these plans are exempt from the claims of creditors in bankruptcy and from judgments. So again, you take that example that you get sued because you're in an auto accident and deemed at fault, and you get sued for $1 million. And let's say you only have $500,000 of auto insurance. Now there's an additional judgment against you for $500,000. If you have a 401k or you have an IRA or you have an annuity or 403b, those qualified retirement plans are generally protected. But there is a cap on that protection, and that federal cap, particularly for IRAs, whether it's a Roth or a traditional IRA, and pensions and other qualified retirement plans, the current amount per person of that exemption is $1,362,800. So in my example, that $1 million judgment and $500,000 is paid by David's auto insurance carrier. There's now a $500,000 judgment against you, and you have a $1 million IRA. That will be protected because that is under the $1.362 million amount. So retirement plans are a good way not only to preserve some wealth and protect it from creditors, but in addition to many of the reasons that David has probably explained to many of you over the years, it's also a great retirement savings plan. So we certainly encourage the use of retirement plans from an asset protection standpoint, and there are some nuances state by state that will allow a judgment creditor, such as that person that was in that accident, you were at fault and you injured someone, to claim a right to, but those are very limited circumstances. If you have in excess of $1.3 million in an IRA, you can use what's called a conduit trust, C-O-N-D-U-I-T, conduit trust. And this is a special type of trust that is designed to own and often be the beneficiary of an IRA, an individual retirement account. This is similar to the use of an ILIT, an irrevocable life insurance trust for insurance policies, except a conduit trust is designed specifically to own a retirement plan such as an IRA. And similar to the ILIT, we would have a separate taxpayer identification number, and it is also an irrevocable trust. So we can further shield these retirement accounts from creditors. It also has certain tax benefits by using these conduit trusts, but I'm going to save those discussions for another day because it's a little bit more complicated and is more regarding the estate planning side as opposed to asset protection side. But just keep in mind a conduit trust for retirement plans, and for those that either have concerns about asset protection or they have concerns about younger children, minors, or even in their 20s or 30s, receiving a large amount of retirement benefits such as an IRA, retirement funds, the use of a conduit trust may be a very good option. Another point with the conduit trust is potentially if you are concerned about a divorce. Now, I represent a lot of spouses in terms of married couples, so I don't necessarily say, okay, here's, you guys want to keep everything separate in the event of a divorce, but often retirement accounts will be commingled. In the event of a divorce, the other spouse may claim a right to certain retirement accounts. By using a conduit trust, you will very likely be able to shield those assets from potential ex-spouses. Next, limited liability companies, LLCs. These instruments, it is a type of business entity, and there are a lot of businesses out there that use limited liability companies, but they can also be used for individuals. It is a very strategic tool in asset protection planning. I have many clients that use LLCs to own rental properties and other real estate. They sometimes will title their vehicles in the name of an LLC, and they often use it for other assets. If they own planes or trains or boats or those types of methods of transportation, we will often use a limited liability company to own those assets. Let's start off with rental property because that is the most common manner in which we use LLCs for individuals. The evolution of rentals has evolved such that Airbnb and other similar companies have afforded our clients the ability to rent out their properties on a very short-term basis. And it can be very nice to have these short-term rentals, and our clients derive a lot of benefits from doing so, but also it can create a significant liability. You have an influx of strangers that are coming in and out in a revolving door, and often they don't have rental agreements in place, and they often don't have rental insurance. For those of you who are in the landlord business and have rental properties and you have long-term tenants, I strongly recommend that you use rental agreements and you require all of your tenants to purchase insurance, rental insurance, so that if, let's say David has a home and the home goes up in flames while a tenant is in there and all of their personal property is in the home and is demolished in a fire, now that rental insurance policy that your tenant had would kick in, and they're usually very cheap, maybe $100 or up to $200 for a whole year to get rental insurance, and you can require that in your rental agreement so that can shield a significant amount of liability in terms of the tenant's assets that may be in there. So by transferring the property to a limited liability company, you are now shielding that asset. So let's say David has that rental property and he transfers it from his name alone into a limited liability company. And now there is an accident and a tenant slips and falls on some ice, and David, under his rental agreement, was responsible for salting the driveways. So now he gets sued. Well, he will probably be named in the suit, but the LLC will also be named, and we will likely successfully defend the action such that David will not be personally responsible, and they will only be able to potentially successfully sue the LLC. And the LLC will only own that rental property. It won't own any of the bank accounts or the cars or any other assets that David has, so he is able to shield himself from personal exposure to all of the other assets, and likely the rental property will be the only asset that will be available to creditors. And if there is proper homeowners insurance and potentially an umbrella policy, he will hopefully be in pretty good shape from avoiding liability. When you have an Airbnb and you have constantly tenants that are coming in a revolving door, that is really where you probably want to be. However, nothing is completely that simple, so you need to take into consideration whether you have a mortgage on the property, because if you do, you now are transferring the property from your name to an LLC, and you are going to trigger what's called a due-on-sale clause in your mortgage, and you're going to have to notify your lender. And while sometimes lenders will permit you to transfer the property from your name to a LLC that is solely owned by you, it can trigger that due-on-sale clause, and we need to ensure that the lender approves in advance. Another issue that comes up is your title insurance policy. Generally, when you purchase real estate, you have to purchase title insurance with it so that if there is an issue with title and somebody 20 years from now says, oh, actually, I owned this property and the recording office messed up the deed and the people who sold it to you didn't even own it. Now you have title insurance. But if you have sold, the property from your name to the LLC, that title insurance policy may become invalid, and you may need to obtain an endorsement to your title insurance policy. So that's something to keep in mind. And you also need to update your homeowner's insurance or liability insurance policy to reflect the name of the LLC. And you need to take into consideration potential transfer taxes. When you transfer a property from your name into a limited liability company, it may implicate transfer taxes. That is a state-by-state issue, so I'm not going to get into the weeds too much for that, but it's something that's very important to keep in mind before you start transferring a property to an LLC. Once you have decided that you don't have a mortgage on the property and you have no issues in terms of transfer taxes, and you've now decided you're going to transfer the property to an LLC, you will generally form the LLC in the state in which the property is located. If the property is located in Pennsylvania, you'll form a Pennsylvania limited liability company, and you will generally, if you're the sole owner, elect to be taxed as a pass-through entity, meaning that you will be reporting all of the income and losses on your personal 1040 tax return. You won't need to file a separate tax return. But it is important to open up a separate bank account in the name of the LLC, and you should have an operating agreement that outlines the ownership and management and control of the LLC. And as rental payments come in, they should go into a bank account in the name of the LLC. And then as soon as they hit that account, they can be transferred to your personal account. But it's very important to keep those assets separate and apart from your day-to-day assets in your name, so that if that day comes when you get sued and the LLC owns the property, we can show that it was truly a separate entity and everything was done separately so that you can avoid exposure from creditors. Let's talk about vehicles. One of the most dangerous and biggest exposures for most of my clients is driving, is their car, being in a car accident. And it is a common mechanism and becoming more and more common to transfer the title to your vehicle into the name of an LLC, just as we would do for the real estate. Again, there are some catches, and the first thing you need to do is try to get the property into the LLC by ensuring you have auto insurance. And if you have auto insurance, you need to ensure that the auto insurance carrier will allow you to transfer the property to an LLC. Assuming that they do so, you may want to do that so that, again, we are narrowing the focus and only going to expose that vehicle to potential creditor claims. I have one trivia question for you. There is only one state in the United States that I am aware of that allows you to form an LLC without listing the owners at all, not even to the state. And that state is New Mexico. So for those that really want privacy, you may want to consider forming an LLC in New Mexico. And then you will also have to likely register it to do business in the state that you are in. But it is an interesting little quirk, and there's only 4 states that offer anonymity, meaning that while you have to report to the specific state who the owners are, and that is Delaware, Nevada, and Wyoming, in addition to New Mexico, you don't have to publicize who the owners are. So that's why those states are so common in using and forming LLCs. I discussed the commingling, so we're now going to talk about collections. I talked about how there are creditors, and there are primarily 3 ways that creditors will pursue you. It can try to get a lien on your property, on your real estate from a judgment, so that if you then go sell the property several years from now, once that property is sold, that creditor will get paid. You have a levy, where they actually try to get paid immediately, so they will be able to try to levy on a bank account, meaning that they have a judgment and the judge will allow you to go into a bank and actually obtain the funds. And then wage attachment and garnishment are used interchangeably, meaning that you can obtain the funds from the employer. You go to the employer and you say, hey, I have a judgment against this person, and right out of their check from the employer would be distributed right to that person who is the creditor. Irrevocable trusts are a really good use of asset protection planning because, again, you have a separate taxpayer identification number. It can shield you from estate taxes and inheritance taxes. It can provide you eligibility for Medicaid. And assets that are titled in an irrevocable trust are exempt from creditor claims, other than when that irrevocable trust is actually sued themselves. Again, the only catch really to this, because there's always a catch, is that there's a look-back period. And each state is a little bit different, but generally that look-back period is about 3 years. So if David transfers his home into an irrevocable trust today, and he gets sued 3 years from now, he likely will be exempt, and that asset will be deemed to be owned by this irrevocable trust. Now, he would have to generally appoint a trustee, so he has lost control of the asset in the irrevocable trust, but it would be exempt from creditor claims. Now, some clever attorneys have come up with a way around that in the use of self-settled trusts. Self-settled trusts allow you to set up a trust for your own benefit, and they are irrevocable. The most common states that we do that in is Nevada and Delaware. And so you can set up a trust even if you're not in Nevada or Delaware, but you would need a trustee who is in those states and in, say, Nevada or Delaware to serve as a trustee. And it can be set up by you for your own benefit and will exempt all of those assets from creditors. In terms of how we want to title assets, generally, if you are married, you want to have your assets, your joint bank accounts titled in your names jointly. Even if one spouse, say I'm working with a client now, one is a radiologist and one is a teacher. And the radiologist obviously has significant asset exposure. The creditors, the teacher, not nearly as much. But it is still better to title assets jointly as husband and wife because there is significant asset protection in virtually all states to assets that are titled as husband and wife if only one spouse encounters a creditor. If you are single, it won't matter as much, but for those of you who are married, you almost always want to title all of your bank accounts in the names of husband and wife, and that is deemed to be what's called tenants by the entirety, which cannot be severed if only one creditor encounters, one spouse encounters creditors. Same thing applies for UTMA accounts, UGMA accounts, and 529 plans. Those are generally exempt from the claims of creditors, and you will not have to worry about them. So they are also very good vehicles to use in asset protection. So in conclusion, we want to ensure that you have proper umbrella insurance, you have proper property casualty insurance on your home and auto, that you invest in retirement accounts, utilize LLCs for rental properties, and remember to trust your trusts, and take a look at your state laws and speak with an attorney who knows the state laws in that particular state to ensure that you are maximizing your asset protection. And if anybody has any questions, I am more than happy to answer them either now or offline. As David knows, I'm always happy to be a resource and try to help anyone out at any time. David?
Thanks, Mike. To be true to our commitment of keeping this around 30 minutes, we aren't going to address any questions at this time. But as I mentioned earlier, please feel free to send us any questions, and we'll be sure to get them answered for you. Real quick, I wanted to share with you that this webinar will be recorded, and we will have it posted on our website for easy future access. And as always, please feel free to share this with anyone that you'd like. And lastly, please save the date for our next webinar, which will be on August 14th at noon. It is our mid-year economic and market update with our very own investment specialist, Mike Horwath. Thanks again for attending, everyone, and enjoy the rest of your day.